I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Good morning. Happy Tuesday. Happy Tuesday. Hello, jurors. It is good to see y'all. We have a big day today. Big day today. Couple things while I'm getting this pulled up. We have... let me boost this real quick because Lord knows you can't hear them. We have a few things going on today. Obviously, we have Karen Reed happening this morning. Big day in this trial. We are going to watch today as they do the, I got something in my eyeball, as they do the hearing for the motion to dismiss and to disqualify the district attorney and sanctions and all kinds of mess this morning. So that's on our agenda first. Big day. You know, last time we watched, they did change the date of the trial because we were actually supposed to be starting the trial right now. But it got pushed back because of all of the info that, all of the discovery and all the things that they got from the Fed's investigation. So they took time to, here, let's watch this while we're waiting. We'll watch them come in. But they are push back the trial a little bit to give them time. So today we are going to hear the motions. I know Auntie Bev won't dismiss. She definitely won't dismiss. She don't want to dismiss. She wants, they all want this to go to trial. So, but you know what? It's a good thing if it goes to trial because, I mean, well, you can look on the bright side of it anyway, because there are so many. I was just talking about this yesterday to somebody. People on either side. Let me mute them. People can, on both sides, can read the same document, and one side will be like, oh, yep, look, this is completely supporting the defense. And the other side will read it and they'll be like, look, this is completely proving that the defense is wrong. So there's so much misconception about so many things, and there's so many things that are, twisted and just ran with, and the vitriol from both sides on this case is just like nothing I have ever seen. And there's still a lot of information that we don't have. So, I have poured through court document after court document after court document, but there's still a lot of information that we don't have. So, if they do a trial, then at least, a lot of that information will come out. So, we'll see. We'll see how it goes. Oh, are y'all getting booted already? Dang it. Yesterday, I don't think it booted hardly anybody yesterday. Yesterday was much better. Maybe today will be like that too. Also going on today, so the trial that we are watching, the one we started yesterday, there were opening statements. It's not opening arguments, it's opening statements. There were opening statements. They did not have them on the stream yesterday, but they posted them after. So when we do, once we finish this and we get ready to go through our speed trial for day 2, we can watch those too. I don't think they're that long, but I saved them on here. But we were talking about that yesterday about how it was so weird that they just went straight into the witnesses. Well, that's because they didn't have it. They didn't have the stream live when they did the openings. So we can go back and watch those too while we're speed trialing today. And the other thing we have going on this morning is, kind of this morning, kind of this afternoon, we'll have to see what time, is Scott Peterson is back in court today. He has a hearing today, a status hearing today, where he may be getting a new trial. So I have gone down this rabbit hole the last couple weeks, looking at all this stuff, and so that'll be really interesting to see. I've told y'all before, the Scott Peterson and Lacey Peterson case was that was a big one for me when I was younger. I was pregnant when this happened, and I thought it was so sad. It hit me really hard that, this, pregnant lady with her baby Connor, Connor never got to have his life, and that made me so sad. So I actually named my kid, his middle name, I named him after Connor, because of that case. And I have hated Scott Peterson for 20 years. And now looking at all this stuff, I'm like, everything I knew about it, I relied on national media coverage to tell me. And now, when you actually look at the evidence, it's not what it was made out to be through national media. And there were a lot of missteps in the trial, and there's a lot of questions. So I am not convinced one way or the other at this point. I'm just going into everything with an open mind. But I was actually kind of shocked at some of the stuff. I see y'all saying Scott Peterson can stay in jail, whatever. Everybody's entitled to their own opinion. I've hated him for 20 years, like I said. But I will tell you this. I am actually really surprised at some of the stuff I saw in the trial. And no matter what you think about who everybody deserves, even the worst of the worst. Like I said, even Alex Murdaugh too. The worst of the worst still deserve a fair trial, and I'm surprised at some of the stuff I read. Very interesting stuff. So I am not, like I said, I'm not convinced one way or the other, but I have an open mind. All right, let's see. Let's see if I can pull up. Oh gosh. I don't know what time his hearing is, but we'll have to see what we can find. Yeah, he's easy to hate. Look, the thing is, even if he turns out to be, they say that they have exculpatory evidence that can exonerate him, and even if he turns out to be not guilty, I'm still never going to like him. Dude was a creep. He cheated on Lacey. He still ain't going to be on my Christmas card list regardless. But, we'll see what happens. We'll see what all they come up with. All right, let's see. I have this view, but I'm going to see if I can pull up the camera view from in there. I'm pretty sure it's at 9 Pacific, I think. I looked it up the other day. Pretty sure it's at 9 Pacific, which would be, 11 my time? but we'll see what happens. All right. So let's do a poll while I'm pulling this up. Start a poll. Do you think Judge Cano will approve any of these defense motions today? Yes or no? We'll see. We'll see what y'all say. Good morning. Good morning. Hot mic. Hot mic. We'll go to the good feed when it starts, but this way we can at least watch and listen beforehand. Hot mic. It's funny, 73% of y'all so far say that she's not going to approve any of the defense motions today. Not surprised. Not surprised. Connie, happy 7-month anniversary. Hey, Brady and friends, so good to be here. Last 7 months have been wonderful, and so glad to have Brady all to ourselves again. Yay. I know, it's been really weird not getting up and having to go to treatment the last couple days. Really weird. Hot mic again. Hot mic again. Everyone's fine.
Yeah. Right. We need it by Friday, so whatever you want to do. You want to add it at 3 a.m.?
It's nothing exciting, but they have the, what are they doing today? I know they're doing the motion to dismiss, the motion to disqualify the DA.
Just train all the way down to the car.
Sanctions. Those are the only 3 I remember. There might be more. And then today was a deadline for something else too. I had it in my notes. I need to pull it up. Melissa Ann gives you the membership. Melissa Ann gives you membership. It went to Ranch Life 30. Ranch Life 30, welcome to the green side. Melissa Ann, thank you so much. Thank you, thank you. Oh, you can hear it now. It was hot mic a minute ago too, but it was
one of the better places. One of the best places.
Very faint. There is a crowd outside. I did see that. They
never heard of it.
Were
I forgot the name of that. I've heard of something, a restaurant in East Boston that is
Well, you can see
supposed to be like one of the best in the country.
talking right here too. They had, let me see if I can pull it up. I saw a video. They were out there,
I never heard that.
crowds and protesters and all that. Let's see. I'll pull it up.
Yeah. Oh yeah.
On the lawn that had begun to take some snow cover. And his torso was pristine. His hip area pristine and his legs pristine. Somebody being hit by a car, I would submit, does not look like they had been punched out by Mike Tyson.
Now, we've...
That, of course, is her attorney. I wanted to...
Fortunately. Yeah, it's just random. We went out, my wife and I, one night. This was a couple of years back, and then we're just like, we saw the sign, like, you want to try it? I've never had Brazilian. It was really good. Argentinian, we were in Aruba, actually. We went downtown, and then we tried every restaurant that was there, yeah. And one of them was Argentinian. It was really good. Yeah. The meat is really good. I've never been. It's a nice island. It is a happy island. Yeah. Yeah. Oh, always. Always perfect. Yeah. Mm-hmm.
Still trying to... Right now, they're... Oh, they're about to get started. So they're starting on this one, which means the other one's delayed just a little bit, but it means they're about to start that one. So we can pull that one up because it's a better feed. We'll leave this one up until the other one starts there. But it's better, it's easier to see, easier to hear.
I didn't. I actually was the only before came. It was all my wife. Yeah. And that was the best assignment actually. But well, we did. I did January and I did some in the summer because period of time between the years. So we did a few appearances in the summer and one during the fall. And there was one couple in January, but it was still warm. Okay. And I remember one night they asked me to go on Sunday night. And Monday we were getting a storm. Yeah. Nobody was able to get on the island. I was the only media on the island.
Do you hear the hot mic?
I was back to the DJ. Yeah. Yeah. He's good. He ate that first food. He could not say anything.
I don't think
they
he
ended up
knows.
dropping the
Has no clue.
So it was interesting on the Hernandez game. Yeah. Mm-hmm. That's on the line. Yeah. Yeah. I mean, technically, they got him off on both cases, technically. I mean, he put himself while they're feeling, so the fiction is on. You know? Thank you.
I'm like trying to listen to the hot mics. Okay, I'm gonna stop from this one, and we'll go to. Here, let me go to this one real quick. It's better. Let me.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Attorney David Yannetti for Karen Reed.
Good morning, Ms. Tianetti.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little. Good morning, Ms. Reed. All right. So, when we were last here on February 26th, I first anticipated that today would be for all motions, but I did read the very detailed affidavit from defense counsel regarding dates and what we should cover. And so today, as you know, I changed some of the dates to accommodate you, I think there was some short trial dates you may have had or restitution dates. And so you did get the order on the new dates. So today is only for filing all Rule 17 motions and for the motion to dismiss under Odell and the motion for sanctions. So I don't remember if it was Mr. Jackson or Mr. Yannetti who last time said that I was operating from a blind spot because I didn't have the information that was disclosed to you folks from the U.S. Attorney's Office. So you were good enough to get me the entire packet, which I appreciate. I read it. I see now how the federal investigation began and when it began. I've also read the pleading. So the motion to dismiss, defendant's motion to dismiss is around 50 pages with attachments. The supplement is about 15 pages. The Commonwealth's opposition is about the same. The motion for sanctions is about 30 pages. There's no supplement, Mr. Yannetti?
There's no supplement.
Okay, and then the Commonwealth had about 25 pages, and then the Commonwealth supplement covered both motions, and the Commonwealth had originally probably hundreds of pages of exhibits. So I have read all of that, and I am mindful also. I keep coming back to the letter that was written to me on February 26th from the Deputy U.S. Attorney, who says, "We expect, of course, that the parties will disclose orally the materials in court only as necessary to further the proceedings." So I've read everything. I'm going to give each side 10 minutes, and we're going to start with the motion to dismiss. So, Mr. Jackson, I'll hear you. I think it would be particularly helpful if you were to focus on the exact prejudice to the defendant and how this all goes to the core of the Odell motion. And as you know, that's an awfully high bar. So, go ahead.
Your Honor, I will try to edit my comments to stay within the 10-minute mark. It's very difficult to do that. I did not know that we were going to be under such incredible time constraints. As a matter of fact, I thought that the court said the last time we were in court, we had basically your words.
Yeah, all day. But that was when we had all the motions. But it's just these two motions today.
But they're big.
They're big.
Consistent with.
Why don't you go ahead and start? If you need additional time, tell me. But it would be important to focus your argument. Again, I'm mindful of what the U.S. Attorney said to me in that letter.
And I am as well. And that mindfulness suggests that my comments will be directed to that which is necessary to further the proceedings.
Okay.
Which means that.
Right ahead.
I'll start with the basic rule of Odell. We start with the postulate that any distortion of the evidence, that's where we start, any distortion of the evidence during the course of a grand jury proceeding impairs the integrity of the indictment, if there is an indictment, and pursuant to Odell, that requires dismissal. In this particular case, there were myriad examples, which I will again, I'll edit. I was going to go through several, but I'll just touch on them very quickly.
Your memo, I have to say, your memo is very thorough and very helpful to me because you outline everything, and same in your supplement.
Thank you. The first point I want to discuss is what we believe is the failure to disclose Sergeant Michael Lank's personal lifelong relationship with some of the individuals, specifically the individual Chris Albert. There was a comment or an incident, I should say, that we referred to in our moving papers that dealt with Chris Albert and Sergeant Lank years ago. They have a long-standing, years-long relationship, and I'll close this loop in just a second, but if you'll allow me, that relationship goes all the way back to 2002 at least. And there was an incident in which Sergeant Lank and Chris Albert had gotten into what can easily be described as a bar fight. Chris Albert had gotten into a bar fight of some sort. Michael Lank walks out of the same bar or an adjacent bar. He had been drinking with his buddy Chris. He walks out, stumbles out, announces to the participants in this fight that he was quote unquote deputizing himself, and ultimately came to Chris Albert's aid. That was with the specific intent to assist an Albert in getting out of a legal jam, all the way back to 2002. The reason I bring that up, and by the way, both of the individuals involved, not Sergeant Lank, both of the other individuals involved were ultimately arrested by Sergeant Lank. That case went to trial, and both of the individuals were found not guilty of assault. And that's after Michael Lank engaged in fisticuffs with at least one of the men, to the degree that the Canton police officers had to pull him off of the individual.
So this is in your memo, and it also is exhibits C through E attached to your memo.
And the reason this comes to a head, and the conflict of interest comes to a head, is because Michael Lank ultimately was the first person to walk into Brian Albert's house. During the course of the grand jury, nobody elicited information from Michael Lank that he had a close personal relationship with the Alberts, that he had in years past come to the Alberts' aid. And yet he was the first person that came into the house. Even the grand jurors were stunned by this and asked, the specific grand jurors asked Michael Lank and asked the Commonwealth, or through the Commonwealth of the witness, why didn't Brian Albert ever even come out of the house? And I think we have the answer. And the answer is because the Albert, specifically Brian Albert, was waiting on a friendly. And they got that friendly through Michael Lank. That was withheld from the grand jury. Sergeant Lank is a longtime childhood friend of the Alberts. The Canton Police Department was conflicted off the case because of those personal and familial relationships that the Alberts have with Canton Police Department. And Sergeant Lank has a history of using his position as a police officer to shield the Alberts from criminal liability. That was never brought out. That's the kind of distortion that Odell talks about. Another broad example or a broad category that I want to discuss briefly deals with Trooper Michael Proctor. The Commonwealth withheld from the grand jury clear and even more egregious conflicts of interest as they pertain to Michael Proctor. Sergeant Lank was aware of this irremediable conflict that Canton Police Department had and that he should have had with the Alberts. So what does he do? He calls in Massachusetts State Police. And who do they send but Michael Proctor? And that's like jumping from the frying pan into the fire. That's the same Michael Proctor who's also years-long close family friends with the Alberts. The Proctors have called the Alberts their, quote, second family. And to that point, now we have benefit of some hindsight, and that's the federal investigation. We have been saying since September 16th, 2022, in lengthy motions that we filed before this court and filed with the Commonwealth, there is a conflict. You're not investigating the conflict. That conflict was never described to the grand jurors. And we've been rebuffed at every single turn. Newly uncovered text messages but from the feds revealed that on January 19th, 2022, think about that date, that's 10 days before the incident. January 19th, 2022, Michael Proctor texted his own family members discussing the specifics of having Julie Albert babysit for his toddler child. We should all let that sink in for a second.
So, yeah, I understand that.
There is a level of closeness that cannot be overstated.
That's huge.
Michael Proctor is so connected to the Alberts that he was entrusting them, or willing to entrust the Alberts, to be caregivers for his toddler child. And it's
That's
not lost on anybody in
huge.
this courtroom that for 2 years, the Commonwealth has been denying it and still denies it in their opposition paperwork. They still say, well, there's nothing to see here. It's Michael Proctor's sister who really is friends with Julie Albert, and that's not a big deal. Everybody looked the other way. As a matter of fact, Ms. McLaughlin wrote the following in her opposition. Trooper Proctor's supposed close and personal relationship with the Alberts is, quote, entirely unfounded and a desperate creation of the defense, a desperate creation of ours. She says we created this. But now we have the benefit of the federal investigation. And the Commonwealth finds itself in that very unenviable position of having to eat some very distasteful words. Because we didn't create anything. And there's more. On February 1st, 2022, 3 days after John O'Keefe was killed, there was another text message. In this one, Michael Proctor's sister texts Michael Proctor very specifically and writes the following, quote, just saw Julie, and Julie said when all this is over, she wants to give you, Michael Proctor, a thank you gift.
Wow.
Michael Proctor didn't respond with, that's inappropriate, these are witnesses, these are potential suspects, please tell her don't ever do that again, don't ever suggest an exchange of gifts again, that would be inappropriate. I'm gonna go write a report, I'm gonna turn it over to Mr. Lally, and Mr. Lally's gonna turn that information over to the defense and to the court. No, that's what he should have done. What he did do is he responded, get Elizabeth one, his wife. In other words, get the gift from my wife, it'll be a little less obvious. So now we have the lead investigator from Massachusetts State Police literally discussing the exchange of gifts between the Albert family on the one hand and the Proctor family on the other hand as a thank you, their words, for helping the Alberts out of a jam. And if you looked up quid pro quo in the dictionary, you would find this set of text messages. 2 years later, to the day, on February 1st, 2024, now let's fast forward 2 years later, now Michael Proctor finds himself on the witness stand in front of a federal grand jury, which we just found out about. That grand jury was tasked with a singular commission, and that was investigating crimes of public corruption by law enforcement in relation to this case. And during that testimony, he was confronted with these and myriad other examples of evidence of his close ties to the Albert family. And he admitted to an AUSA, under very intense questioning, that not only does he know the Alberts, and does he socialize with them, does he drink with them, does he go to pool parties with them, but he told his partner, Yuri Butnick, all of this before Yuri Butnick testified at the grand jury and before he and Butnick actually interviewed Chris Albert. Why does that mean something? Why does that mean something to the court and to this argument? Because when Yuri Butnick testified before the state court grand jury, he testified that, quote, following formal introductions, end quote, Julie Albert and Chris Albert provided their phone numbers. Following formal introductions. That was a clear deceit on the grand jurors. Yuri Butnick knew, as did Michael Proctor, they didn't need formal introductions. Michael Proctor was considering having Julie Albert babysit his kid 10 days ago. Actually, at that time, 13 days ago. That left the grand jury with the intentional false impression that these people literally do not know each other. They've never been in contact. They're complete strangers. That was a lie. That was a concerted effort to hide that relationship and to hide the conflict of interest. And the grand jurors were fooled. They were left with the impression, Michael Proctor, Yuri Butnick, they don't know these folks. They're completely neutral, independent investigators, and nothing could be further from the truth. And the revelation of this evidence culminated in front of that same grand jury on February 1st, 2024. Under additional intense questioning by the Assistant United States Attorney, Proctor was caught in his own web of deceit and testified as follows, quote, this is the AUSA talking, or asking the question. So obviously we're asking questions about your relationship with Julie Albert, with Chris Albert, and with Colin Albert. Do you understand that? Answer, yes, sir. Question, and you're saying that you're minimizing, quote, minimizing your relationship to the grand jury, correct? Answer, yes.
Wow.
He finally, under the scrutiny of a federal grand jury, admitted that he had been lying about his relationship to the Alberts, which means he lied to the grand jury, which means that evidence was distorted in front of the grand jury. And that is the burden that Odell requires.
All right, so your time is up, which includes me interjecting. Do you want 5 more minutes?
If I could employ the court.
I'd like you to sort of get to the questions I asked as well. All right, I know you're reciting the evidence that I've read. So
she doesn't want it on the record.
Thank you.
She doesn't want it
I want
out.
to shift gears to another example or another series of examples.
So huge.
Evidence that was distorted before the grand jury. And that deals with the use of, or the insinuation of Kevin Albert, yet another Albert, at the behest of Michael Proctor. Kevin Albert is a sworn Canton police officer. On day one, the Canton Police Department was completely recused off the case, in no small part because of Kevin Albert. And the fact that John O'Keefe's body was found on Kevin Albert's brother's lawn. Yet the evidence that has been disclosed by the federal investigation, which we were not privy to, is that Michael Proctor actually utilized Kevin Albert's services to coordinate with the very witnesses who should have been potentially suspects and certainly should not have been subject to coordination by an Albert. When that's the very person on whose lawn John O'Keefe, or his brother's lawn, John O'Keefe was found. I want to turn to
this is
at least one more situation in my remaining minute or so, given the fact that this is curtailed. And this is not in our papers, but obviously it's a complete and probably the most obvious distortion of the facts. The Commonwealth suppressed one of the most obvious pieces of exculpatory evidence in the entire case, and that was a piece of evidence that they know torpedoes their entire case and their theory of this case, and that's Jennifer McCabe's Google search at 2:27 a.m., how long to die in cold. They had her phone at the time of the grand jury. They had her complete extraction of that phone at the time of the grand jury. They had a Celebrite report, Your Honor, at the time of the grand jury, and yet they did not present this evidence. They claim, oh, well, we didn't have the right version of the Celebrite software. That's on them. That's not our fault. Certainly not Ms. Reed's fault. That's their fault. Get the right software. If you're going to bring this case, do it the right way. They say their argument is, well, we just didn't have the right software, so we didn't have the information. That's not true. They did have the information. It was sitting in her phone. They just didn't do their job in extracting. And should the Commonwealth once again stand up in some sort of desperate pitch to dispute that time and this critical evidence, the court should note the following. Not only does the Celebrite report confirm the search and the time of that search, not only do our experts confirm the search and the time of that search, but now a Quantico-trained special agent with the FBI's Regional Computer Forensic Lab, in other words, the United States Federal Bureau of Investigation, also specifically confirms that that search was made on Jennifer McCabe's phone, and it was made on or before 2:27 a.m. on January 29th, 2022. That fact, Your Honor, is no longer open for debate. And none of that was presented before the grand jury. I'll conclude by saying any one of these examples, and I didn't touch on all of them, but any one of these examples, the gift giving, the babysitting, the telephone extraction, the Google search at 2:27 in the morning, all of these, any one of these would be enough to dismiss the charges as they sit here today. But the cumulative effect of this deception and all of it, this distortion in front of the grand jury, is too much for the court to ignore. The simple fact, Your Honor, is the presentation before by the Commonwealth before the grand jury in the state court action, it just wasn't fair. That's the easiest way to say it. It just didn't give Ms. Reed a fair shot. It just didn't. That presentation was packed with lies, known lies by the investigators, and the omissions and the manipulations and deceit by the very people that are supposed to be the ones that we in the community can trust. The ones that are supposed to protect our interests, and the law does not allow this sort of conduct to go unchecked. When the remedy when this sort of travesty of justice occurs is established by this state's Supreme Judicial Court, and that is dismissal of the indictment in its entirety. And it is not enough, and I'll be surprised if I don't hear it today, but something suggests, based on the moving papers that we just got from Ms. McLaughlin and Mr. Lally, are, well, Your Honor, we didn't know. We didn't know about the text messages. We didn't know about Proctor. We didn't know about Lank. All that stuff was revealed through the federal grand jury. It doesn't matter that Ms. McLaughlin individually didn't know, or Mr. Lally can say, I claim ignorance, I didn't know either. It's enough that an arm of their institution, law enforcement, they knew. And that was their job to tell the truth. That was their job not to fool or distort the Commonwealth. I'm sorry, the grand jurors. With that, Your Honor, thank you for the time, and I'll submit.
All right, thank you.
Wow.
Mr. Lally, we're going to start with 10 minutes. If you need more, you need to tell me.
That's huge. That's so huge. And it's validating for all the people who told me that Proctor wasn't close to them.
Thank you, Your Honor. No, I think 10 minutes should be fine. I know the court has taken painstaking detail to go through all the material that's submitted, so I'll be as brief as I can. Essentially, the defendant, as the court is aware, doesn't challenge the grand jury presentation under McCarthy grounds or probable cause standard. Defendant motions challenges under Odell. Odell essentially states dismissal of an indictment on impairment of the grand jury proceedings requires proof of three elements, as the court is well aware. One, that the Commonwealth knowingly or recklessly presented false or deceptive evidence to the grand jury. Secondly, that the evidence was presented for the purpose of obtaining an indictment. And three, that the evidence probably influenced the grand jury's decision to indict. None of which I would submit the defendant has met their burden with
I think all
reference
three of
to
those
any
he
of those
did.
three elements.
All three
Just
of those
addressing sort of the overarching themes of the defendant's motion. The defendant challenges, as he just stated, the testimony of Canton Police Sergeant Lank and his testimony attributing statements to the defendant that were made in the aftermath of Mr. O'Keefe's body being discovered in a purported deception of Sergeant Lank's relationship with the Albert family. Trooper Proctor's purported false and deceptive statements throughout the course of his testimony, and the Commonwealth's failure to elicit a purported inconsistent statement of Christopher Albert, and the Commonwealth's failure to impeach Julie Albert's testimony. Your Honor, simply put, none of these issues or stated malfeasance actually occurred before this grand jury. As it relates to Sergeant Lank, I mean, we're talking about what the defendant submits as an attachment is an incident from almost 20 years ago, which doesn't involve anyone who was at the house at 34 Fairview Road on the night when Mr. O'Keefe died. The statements that Sergeant Lank is attributing to the defendant were not only testified to by Sergeant Lank, and they're testified not in a deceptive manner. They're testified to by Sergeant Lank in the sense of he indicated he spoke to officers who had preceded his arrival. All of those officers also testified before the grand jury. All of those members who received statements from the defendant essentially indicating that she did it, that doesn't just come from one source. That comes from at least 5 different witnesses, 3 of them paramedics with the Canton Fire Department. Counsel posits the question of why didn't Brian Albert come out of the house? No one did. Not only out of that house, but any house. It's clearly visible in the grand jury exhibits. You have the cruiser camera footage from Officer Seraph, as far as no one else in the neighborhood coming out of the house, as well as testimony from a number of different witnesses that were there and present on that morning in the dark, in a blizzard, at the time that Mr. O'Keefe is found. Counsel wants to say that the Commonwealth is asking the court or everybody to sort of look the other way when it comes to these things. What I would submit is that's exactly what the defendant is doing. Look the other way, defense by obfuscation. It's essentially, it's a 3-card money trick, card trick on the corner on the side. Look at all of this, look at this relationship, look at that relationship, conflating these relationships, sort of the distortion that I would say between what exists in social media realm and what exists in reality. That if you know someone, that automatically means that you're best friends with them, every single one of their siblings, every single person that they've ever met or socialized with. One social interaction, transforms into a long-standing 20-year relationship, all of those things. And what the defense is obfuscating from is the overwhelming evidence that was presented to this grand jury from a multitude of sources, 42 separate witnesses, 56 exhibits, over 1,400 pages of transcripts, which clearly demonstrate and indicate that the defendant, Karen Reed, killed John O'Keefe. But they don't want you to look at that. They want you to look at who texted who when and what they said and what was asked and what was promised. In reviewing the materials provided by the U.S. Attorney's Office, a couple things that I would note is, number one, they have no idea how much of a percentage of the totality of the federal materials we have. I don't know if we have 5%, 50%, 90%. I have no idea. The other part that's confounding is that it appears that these materials or materials from the state prosecution were provided to the U.S. Attorney's Office by Mr. Yannetti or by the defendant or by defense counsel. And again, what I don't know is how much of a percentage of the total discovery from the state case was actually given and provided to the U.S. Attorney's Office in which to conduct their investigation. But it's clear from the investigation that they extensively investigated the facts and circumstances that led to Mr. O'Keefe's death. In sum, what I would submit, just as Ms. McLaughlin stated on the last day, these materials are largely consistent with the Commonwealth's theory of the case. There is no suggestion of a third-party culprit, no suggestion of cover-up of evidence, no suggestion from the 13 civilians' witnesses' testimony that we've received, or transcripts of that testimony. All of them confirm that Mr. O'Keefe never entered 34 Fairview Road. All of it was absolutely no animosity between the individuals at the Waterfall Bar or at 34 Fairview residence. There was no fight, there was no dog attack, there was no eyewitness to the circumstances that led to Mr. O'Keefe's death. Witnesses also testified consistent a year later. They testified in the state grand jury in the spring of 2022, largely in the spring of 2022, and then largely in the spring of 2023 before the federal grand jury. And their testimonies are largely consistent with the defendants making declarative statements that she did it, not a question mark at the end, but clear definitive statements on scene, that she had discussed the damage to her taillight prior to leaving Mr. O'Keefe's home on the morning of January 29th. You have a number of different statements that were alluded to by Mr. Jackson in regard to texts from Trooper Proctor's phone. Of note, there are no text messages between Trooper Proctor's phone and Julie Albert's phone, except for two no-content text messages, one from June 21st, 2020, and one from September 1st of 2020. There is a discussion between Trooper Proctor and his sister because Julie Albert had provided child care in a pinch on several occasions for Trooper Proctor's sister. Trooper Proctor also testified that Julie Albert never did that for him, never watched his kids, never had looked after his children. That essentially never happened. Lastly, get to the Google search, and I would agree with counsel in the sense that it's really no longer open for debate. But I'm not really sure why we're still even talking about this or why this is still a topic that they're pushing. Essentially what we have is, yes, what counsel mentions is there is one expert who was given two extractions, presumably provided by defense counsel, that indicates from that particular FBI expert that the searches were done at 2-something in the morning. What counsel neglects to sort of raise and stress with the court is that there's a separate, and I forget exactly what it stands for, but an RCFL analysis of the phone in which through both Axiom and through Celebrite, and that conclusion of that expert is that the searches occurred when Ms. McCabe testified they occurred because the defendant asked her to conduct those searches at 6:23 and 6:24 in the morning. Really, the argument stops at the point of it's not, we didn't do our job to get the Cellbrite version that shows that information did not exist at the time of the grand jury. So I'm not really sure how the Commonwealth is supposed to run something through a Cellbrite version that isn't in existence at the time the grand jury is conducted. It's a subsequent version in which their expert, Mr. Green, finds these purported search without looking at the cache files, without looking at the DB list, without looking at the SQLite database, without looking at the wall file, all of which was done not only by Trooper Garino, an independent expert named Jessica Hyde, which counsel has all of that, as well as the senior technical analyst from Cellbite itself, a man named Mr. Whiffen. Counsel's had this report for months at this point. And essentially, Mr. Whiffen is essentially the person who creates the software that all of these experts are using. And his definitive opinion indicated in his report is that Ms. McCabe conducted those searches at 6:23 and 6:24 in the morning. So I would agree with counsel that it's really no longer up for debate. I think we just disagree as to the conclusions of that. But based on the totality of the evidence and what I would submit as the overwhelming evidence that was presented to this grand jury, all of these sort of individual parsing of stated malfeasance simply doesn't even come close to sustaining the burden under Odell. And for that reason, I would ask that the court deny the motion to dismiss.
Okay. Do you want a few minutes, Mr. Jackson, to respond?
Very briefly.
Okay.
First of all, it's always interesting to hear an argument that suggests there's nothing to see here. That's exactly what Mr. Lally did yet again. He said, look the other way, look the other way. Oh, it's the defense that wants you to look the other way. We don't want you to look the other way, Your Honor. We want you to look directly at the evidence of the compromised relationships that Trooper Proctor had and hid. That's what we want the court to look at. He suggests, oh, well, there's just a couple of text messages. It's no big deal. The fact is, Your Honor, she really hit him. She really hit him with the car. Let's remember, she really hit him. And these text messages, they mean nothing. We're talking about the integrity of a sitting grand jury and the presentation before that grand jury. What Mr. Lally now has in his possession, but he didn't mention, now that he says, oh, well, she killed him. Let's just get on with it. She killed him. He's already tried and convicted her in his mind and tried to do it in this courtroom. Doesn't quite work that way. Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body.
Wow.
In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop. That's their independent expert, not ours, not somebody on our payroll like Mr. Whiffen or one of their experts or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally that car did not hit John O'Keefe, and John O'Keefe was not hit by that car. But he didn't mention that. Second, he argued that the texts were not, these aren't texts between Julie Albert and Michael Proctor. These are texts between his family members. And then he mentions these 2 texts that had no content. What are the chances that Michael Proctor sent Julie Albert texts with no content? Your Honor, it's not that they didn't have content, it's that it couldn't be recovered, which sometimes happens. But we do have evidence that they were in fact in communication with each other as early as 2020. And with regard to the 2:27 a.m. search, it's not a 3-card Monte. It's not a shell game or whatever other fanciful thing Mr. Lally wants to suggest that it is, as he tap dances his way around this. He says that our expert, Rick Green, didn't look at the SQLite database. Yeah, Mr. Lally, reread his report. Yes, he did. He didn't look at the wall file. Yeah, Mr. Lally, reread his report. Yes, he in fact did. And he's the one that found the 2:27 a.m. search. And with regard to the Regional Computer Forensics Lab, that's the definition he couldn't remember, what they actually said was, because Mr. Lally got this wrong too, what they actually said was, yes, there was a 6:23 and a 6:24 search. And there was a 2:27 a.m. search as well. All 3 of those searches existed in the phone, Jennifer McCabe's phone, and it's not up for debate. That wasn't presented to the grand jury. The information that we've been talking about today wasn't presented to the grand jury. We're talking about the integrity of a proceeding. He doesn't get to convict my client by standing up here and pounding the table and saying, oh, she did it, she hit him. So let's just all get on with it. Deny this motion. We're talking about the integrity of what is the foundation of Massachusetts' judicial system. And that integrity was compromised, that integrity was impaired. And it demands that justice be done. And that justice is in the hands of this court. We ask this court to do what the evidence dictates, do what the law dictates, and that is dismiss this indictment. That is the only way justice will be found in this case. Thank you.
All right. Thank you very much. Mr. Yannetti, are you all set?
Yes, Your Honor, thank you.
Wow.
So at the same time, and let's see how you do with it.
That's so huge. We'll talk about all this when it's done.
We believe our witnesses. They are telling the truth. Karen Reed is guilty. Any suggestion to the contrary is a desperate attempt to reassign guilt. Can you imagine a district attorney with a sworn duty to do justice and respect the presumption of innocence issuing such a statement in a pending case? Before August 25th of 2023, I could not. Yet that was the message of Norfolk County District Attorney Michael Morrissey to potential jurors in this case on that date.
This is her other attorney.
I've been practicing criminal law as both a prosecutor and a defense attorney for over 30 years now. Never have I seen such unethical conduct from a prosecutor. I know of at least one law professor who used Mr. Morrissey's statement in his class to teach his law students how a prosecutor should not act. Another member of the bar has already reported Mr. Morrissey's conduct to the BBO. And now we are here with a motion to disqualify Mr. Morrissey from further prosecuting this case because he has a personal interest in the outcome. Your Honor, this court should grant our motion to disqualify. And at the outset, I note that we've also moved for sanctions, dismissal of these indictments as a result of his misconduct. But we have so many additional grounds for dismissal as a result of the material provided to both sides by the federal authorities that we will be filing a further motion to dismiss for extraordinary governmental misconduct. My co-counsel has spoken to that previously. To the extent that the court entertains our motion for sanctions, specifically dismissal, as a result of his egregious...
Can I just interrupt there and ask you, are these going to be the same motion, essentially?
No. There's information and evidence that's been provided by the federal authorities which deals with the egregious conduct of both the district attorney and his investigators and the police. That will be the subject of a separate motion, Your Honor.
So I thought that was going to be your supplemental memo to this motion. It sounds like it's the same issue, Mr.
No,
Kennedy.
it's not. And what I'm saying to the court is I have limited time.
When I interrupt you, I stop the time.
Well, I appreciate that. But even with that, Your Honor, the focus of my argument is going to be on the disqualification as opposed to the dismissal. I've submitted papers on the dismissal. I will rest on those papers with regard to that issue. That's my only point.
All right, so when you file the other motion, I need you to include in your memo how that's different specifically from this.
Understood.
Not just the remedy, but how the basis of it is different.
Understood.
All right, so I'm going to start you again from scratch. Go right ahead.
I appreciate it. Well, Your Honor, this case admittedly has been an unusual one for a district attorney to deal with. The district attorney's office is not accustomed to a criminal defendant fighting back in the way we have prior to trial. What usually happens when the prosecution brings charges is they detail the allegations at an arraignment in court, and as a result, their narrative and theory of the case becomes widely reported, while the defendant and the defense team remain relatively quiet. After arraignment, moreover, the media typically lose interest and wait until a trial or potential resolution of the case before they start reporting on the case again. And in this way, the district attorney's office is quite accustomed to always controlling the narrative in pending cases, at least until the defense makes an opening statement at trial. And as long as the prosecution gets to control the narrative in the press, they have no problem with what's being reported. But of course, this case has been different. Their control of the narrative did not last very long here. In our view, it became clear very early on in this case that their narrative was wrong. Their theory of the case was wrong. Their allegations did not fit with the evidence that we fought so hard and for so long to get access to over 2 long years. So along the way, we spoke out about our findings of exculpatory evidence, mostly within this courtroom, but occasionally outside. The DA was not used to that and apparently didn't like it because they initially sought the extraordinary remedy from this court of trying to gag the defense from exercising our First Amendment rights to discuss a client who at all times is presumed to be innocent. And as you know, they filed that motion on June 9th of 2023, and it didn't work. The court denied the motion, specifically ruling that any statements attributed to counsel could generally be characterized as responses to the accusations against Ms. Reed and are therefore permitted under the rules. When you made that ruling, though, Your Honor, you admonished both sides that commenting on the credibility of witnesses would have a prejudicial effect on the proceeding. And at that point, we largely stopped making extrajudicial statements. By contrast, Norfolk County District Attorney Michael Morrissey, only 25 days after that court's ruling, instead decided to blatantly ignore this court's admonishment. DA Morrissey went off the rails, gave an unprecedented video statement to the media where he specifically vouched for the credibility of Commonwealth witnesses in violation of the rules of professional responsibility, in violation of this court's order. A member of the public issued a public records request, and we got this to show all of the media outlets that DA Morrissey made sure received his statement. Before any trial has occurred, he called the defense theory in this case, quote, a false narrative. Before any trial has occurred, he announced his opinion that nobody within the home at 34 Fairview participated in any murder or any cover-up. Before any trial, he vouched for the credibility of Commonwealth witnesses Jennifer McCabe, Matthew McCabe, and Brian Albert. He announced that those witnesses were forthcoming. In other words, truthful. Before any trial has occurred, DA Morrissey announced that the defense theory is, quote, a desperate attempt to reassign guilt, end quote. Given those broad statements of Mr. Morrissey's opinion that Karen Reed is guilty, can you believe that the DA in their opposition to this motion had the audacity to claim that DA Morrissey's words were narrowly tailored to the harassment of witnesses? It goes without saying, but your words are not narrowly tailored if you're a prosecutor vouching for the credibility of witnesses, particularly after a judge told you not to do that. Your words are not narrowly tailored if you're announcing to the public that you've already assigned guilt to a criminal defendant before trial. A desperate attempt to reassign guilt. DA Morrissey announced to every potential juror in Norfolk County not that someone charged with a crime is innocent until proven guilty. The words innocent until proven guilty never came out of his mouth. Instead, he announced his office had already assigned guilt to Karen Reed. So in his view, when she fought back by reasserting her right to be presumed innocent, he deemed that a desperate attempt to reassign guilt. Never, in over 30 years of practice, have I ever witnessed an elected DA so blatantly violate the rules of professional responsibility. Never have I witnessed an elected DA trample on the constitutional rights of a criminal defendant who enjoys the presumption of innocence. And I do have some perspective in this area. I had the privilege of spending the first 10 years of my career as an assistant district attorney in Middlesex County. I had the privilege of working with and for some of the finest DAs this Commonwealth has ever seen, from Scott Harshbarger to my mentor, Tom Riley, to Martha Coakley, Jerry Leone, Marion Ryan. In addition, I worked with some of the finest Massachusetts state troopers acting as homicide investigators, men and women I respect for their integrity and prowess as ethical investigators. In a million years, I could not imagine any of my former colleagues and bosses making such a statement. They were professionals with ethics and a humble respect for the awesome power they possessed as public prosecutors. So for those reasons, in some ways, it pains me to have to file a motion like this. But DA Morrissey, through his poor and unethical decision-making, to release a video statement designed to prejudice potential jurors against my client, has forced my hand. So the question then becomes, why did he do this? Why did he take such a personal interest in this case such that he would take the unprecedented, and that's his word, unprecedented step of vouching for Commonwealth witnesses? Why would he take the unprecedented step of denigrating the defense theory to potential jurors? The unprecedented step of announcing to the public that Karen Reed is guilty? Why would he trample over the presumption of innocence and announce that we're trying to reassign the guilt that he's already assigned to her? Well, on December 4th of 2023, we began to learn why. That was when the DA released to us correspondence he had had with the U.S. Attorney's Office, which dated back to May of 2023. That correspondence revealed that federal authorities were investigating this case. And it's worth noting they only released those to us once Fox 25 had succeeded in a public records request, and they knew what they had kept hidden was going to be revealed. And once we got those letters, we learned why they wanted them hidden. We learned that in May of 2023, the DA's office knew there was a federal investigation. They did not reveal that knowledge to the defense. In fact, on June 12th of 2023, the acting U.S. attorney specifically told the DA's office they could reveal the existence of this federal investigation to us, but they didn't. They kept it secret. And then worse, Your Honor, on December 4th of 2023, the district attorney's office provided a false notice of discovery to this court and to the defense. In that notice of discovery, they claimed they had received no confirmation that any witnesses had testified before a federal grand jury. We now know that was a lie. We know it's a lie because 7 months earlier, DA Morrissey wrote that multiple state witnesses had received subpoenas. We know that was a lie because now that we've got the information from the feds, Nicole Albert testified before a federal grand jury that she participated in a group conference call with Jennifer McCabe, Matt McCabe, Brian Albert, ADA Lally, and victim witness advocate Stephen Nelson, a group conference call before she testified before the federal grand jury in July of 2023. We also know it was a lie because he wrote in his letter, and I quote, "We have confirmed that witnesses testified before the federal grand jury." Yet 7 months later, the DA's office tells this court that it had received no confirmation. That is outrageous. We are outraged that he lied to us. This court should be outraged that DA Morrissey lied to you. In a prior hearing in this case, I argued to this court that the letters back and forth confirmed that DA Morrissey believed that he personally and his office in general was being targeted by the U.S. Attorney's Office. I chose my words carefully. I never said he received a target letter. The existence of a target letter is irrelevant. The inquiry is, what does the DA know and believe? And he revealed in those letters what he knew and believed. He revealed that he believed that U.S. Attorney Rachel Rollins had a personal animus against him. He wrote, quote, "She's made no secret of her personal animosity towards me." He also wrote that the head of the public corruption unit at the U.S. Attorney's Office may be personally retaliating against him and targeting him because his wife was unhappy with the way the Norfolk DA treated her. He wrote, in short, that he knew, felt, and believed that he and his office were being targeted. Now, why is that important? It's important because of the immense power that a prosecutor has. It is important because we need an unbiased prosecutor with no vested interest in a case to try to administer justice based on the evidence and not based on any personal interest in a case. It is important because, in the words of U.S. Supreme Court Justice Robert H. Jackson, quote, "We must have assurance that those who wield this power will be guided solely by public responsibility."
So I just want to tell you, you've gone over your time. I see your reading, so you have some idea on how much longer you have. How much longer do you have with that?
Probably about 3 minutes, Judge.
Okay, yeah, go ahead.
Thank you. Indeed, Your Honor, Justice Jackson practically spoke to DA Morrissey from the grave. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have citizens' friends interviewed. Prosecutor can order arrests, present cases to a grand jury in a secret session, and on the basis of his one-sided presentation of facts can cause the citizen to be indicted and held for trial. Well, while the prosecutor at his best is one of the most beneficial forces in our society, when he acts with malice or other base motives, he's one of the worst. In his own words, D.A. Morrissey revealed he has an interest in this case that goes beyond the interests of justice. He revealed that he knew that his office was being unfairly targeted and investigated. And it doesn't matter if his belief or knowledge was right or wrong. It's only important that he believes it. And this means he has a personal interest in getting Karen Reed convicted. If he can use whatever means he has at his disposal to convict her, and he succeeds, that would vindicate him and harm the federal investigation of his office. On the other hand, if she's found not guilty, as we expect she will be, he knows that he and his office will remain in the crosshairs of the federal investigation. And it's important to note, Your Honor, both sides have been made aware multiple times that as we have this hearing today, that federal investigation is still open. They've called most of the Commonwealth's witnesses to testify, but they're not done. D.A. Morrissey has an interest in this case not to do justice, but to win. That's why he hid his knowledge of the federal investigation for 7 months. That's why he slow-walked discovery. That's why he gave a lengthy video statement saying Karen Reed is guilty. That's why he talked about our theory being a desperate attempt to reassign guilt. And perhaps that's why, in contravention of Judge Krupp's preservation order, D.A. Morrissey's office gave the go-ahead to Brian Albert and Brian Higgins to destroy or dispose of their phones. We only learned that because the federal authorities revealed that in their investigation. And I'm just about ready to end. The DA also, as my colleague has indicated, the FBI has confirmed that Jennifer McCabe Googled, how long to die in the cold at 2:27 in the morning. But what has not yet been mentioned is that 5 minutes before that, Brian Higgins and Brian Albert were calling each other at 2:22 in the morning on January 29th after previously testifying they were both asleep at that time. There was a lot of suspicious activity in the early morning hours of January involving the witnesses that Morrissey improperly announced to the public were telling the truth. We're getting to the bottom of it, and the truth will come out. But as we continue to defend her, Your Honor, like any criminal defendant, my client deserves a neutral, impartial prosecutor interested solely in justice with no vested outcome in this case. And it's crystal clear we do not have that in Michael Morrissey. That is why he should be disqualified from this case. And that is why I urge you to do just that in the interests of impartial justice.
All right. Thank you very much. Who's arguing this? You, Mr. Lally? All right, so let's start with 10 if you need more.
Oh, wow. Wow.
Thank you, Your Honor. And again, I don't think I'm going to need much more than that. Again, I know the court has reviewed all the materials, and I know the court is well aware of the standard, and it's a standard which I would submit just simply hasn't been met here. To characterize counsel's actions in this particular proceeding with specific reference to the media and saying it's different, I think is minimization to the highest degree. Essentially, what the defendant is positing, or what counsel is positing in this motion, is that due to a recorded statement by the district attorney over 6 months ago, that impinges on her right to a fair trial, or it impinges, shows some sort of deleterious motive on behalf of the district attorney in the handling of this case. The statement, as the district attorney indicated in it, was in response to an extraordinary degree of relentless and really relentless harassment and intimidation of nearly every witness associated with this case, which included a July 22nd rolling rally of nearly 100 people traveling to witnesses' homes and calling them murderers. That is largely what this was in response to, and is in complete conformity with Massachusetts Rules of Professional Conduct 3.6b6 that permits an attorney to make a warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. It's also in conformity with Rule of Professional Conduct 3.6c, which allows for such statements to rebut the prejudicial effects of the defendant's and her counsel's misconduct. Now, again, I know the court has read through the Commonwealth's opposition, but just to highlight a few of those particular incidents. So yes, the July 31st, I believe, was the ruling in regard to the, for lack of a better term, a gag order. And I think it's been somewhat inappropriately or just patently falsely represented to this court in public what that ruling said. It indicated that the statements of counsel arguably crossed the line of permissibility under Rule 3.6, and that meaning defense counsel. That the inflammatory statements about the Commonwealth and witnesses, particularly by Attorney Jackson, appear to have fueled much of the publicity in this case, and that's a quote from the court's ruling. And that the defense counsel did not have carte blanche to speak with the media, and going forward, defense counsel should ensure that their statements are limited in conformity with the rules. And it denied the Commonwealth's request for that gag order at this time, denying it without prejudice. And then Mr. Yannetti wants to get up here and say that they largely stopped making extrajudicial statements after the court's ruling. And so I guess largely stopping would then include August 22nd, the day before the district attorney's statement, a ABC News broadcast in which Mr. Yannetti and Mr. Jackson were featured for a 9-minute, 37-second segment, in which Attorney Jackson indicated that pieces of taillight were planted after the fact, that the victim walked into the house, I think he was confronted, was likely brought down to the basement, I think the confrontation got physical, and he was beaten to a point of unconsciousness, that he had defensive wounds, bruises on the back of his hands, largely of which is all not only not true, but directly contradictory to the vast amount of evidence that has been turned over in this case. Mr. Jackson then went on to continue that this was a cover-up, and indicating that John was murdered inside that house, his body was placed outside. This also continued into September. September 17th, the defendant, traveling with Attorney Jackson, Attorney Little, and a woman believed to be a television news producer, to the victim's home, to Mr. O'Keefe's home, in direct violation of her conditions of release, where she has to stay away from, as well as other places of interest and sort of tour around the town of Canton. When balancing the amount of public and prejudicial statements made by the defendant and her counsel, the Commonwealth would suggest that then characterizing the district attorney's statement from over 6 months ago, threatening her right to a fair trial, is simply a position that's just untenable. Now, in context, as far as those particular statements, those particular actions go, as the court is well aware, there is a significant history between this defendant, Mr. Yannetti, Mr. Jackson, and the social media blogger, Mr. Kearney, who's now been indicted for intimidation of witnesses in this case. And with reference to that, there is a significant, despite public indications to the contrary, that indications from Mr. Kearney's phone, which was seized, is that there is a precipitous amount of phone communications, indications of communications between Mr. Kearney and Ms. Reed on a signal messaging app, an encrypted app, as well as, I believe, about 189 phone calls over a span of a few months. And that's just what's indicated or contained in the phone. There is also, going back to the spring of 23, direct communications between Mr. Kearney and Mr. Yannetti and Mr. Kearney and Mr. Jackson. They went out to lunch with Mr. Kearney following a court date in May of 2023. And this is a person who counsel in the memo seems to want to distance themselves from, based, I'm presuming, on subsequent indictments. But the truth is in the phone. The phone doesn't lie as far as those communications are concerned, as far as those communications between counsel and between the defendant in this particular case. So to say that this is a different case, again, I would suggest is a large minimization of what actually has transpired here. Lastly, what I'll say in reference to the federal grand jury, what is also clear from the federal grand jury is that this was an investigation which was initiated by the defendant and Mr. Yannetti. So to claim that he was in the dark or didn't know about this federal investigation, every bit of discovery that the federal government has from the state case was provided by Mr. Yannetti. Nothing was asked for from the Commonwealth. Nothing was asked for from the District Attorney's Office, the State Police. So again, what I was intimating before in reference to the motion to dismiss, I have no idea what they have seen or what they haven't seen, how much of the file, how much of the discovery or anything else. It's all sort of been provided and colored by Mr. Yannetti. And this goes back to November of 2022. So to then claim that you were sandbagged or didn't know about an investigation that you initiated over a year before until late in December of 2023 is, I think, disingenuous. Disingenuous would be about the nicest term that I can come up with for that. Thank you.
Right. Mr. Yannetti, a short rebuttal, I guess, or a short comment.
I would just add, Your Honor, that the focus of Mr. Lally's argument was on everything except for Mr. Morrissey's conduct. Just like it doesn't matter if Mr. Morrissey and his office are actually targets of an investigation, it's only what he knew and believed. Similarly, with regard to his conduct in keeping secret the existence of a federal investigation, it doesn't matter whether we knew about it or not. It's the fact that Morrissey knew, kept it secret for 7 months, and didn't reveal it to the defense until the media got access to those letters. And with that, I would rest.
Okay. Thank you. So I do have a question. Did you file the Rule 17 motions already, or do you expect to file them later today?
We will be filing them by the close of business today.
Okay, and they're pretty much outlined in your previous motion, what you needed to file, or are there additional ones in your motion?
I believe they're outlined. Yeah, they're outlined, Judge.
Okay, I asked because Mr. Roach told me that on the March 20th date, the council wants it to be via Zoom. I'd prefer it not be, because with Rule 17, as you know, the record holders come into court and object. So I don't want you all to be on the screen. And Mr. Yannetti, certainly your local counsel. Mr. Jackson, if you want to be on the screen, you can. But I need somebody here.
I understood, Your Honor. That's fine.
Okay?
That's fine.
It makes sense to me.
Yeah. If I may just...
Yes.
Can I appear in person and have my client join me?
No, she has to be here.
Okay. Thank you, Judge.
All right. Was there something else? Yes.
I would ask, may we approach just as the scheduling issues?
Okay.
Wow, there's so much that has just happened here. I'm a little bit shocked over some of the stuff they just said, especially about some of the stuff that came out during the federal stuff. Two biggest things to me right now are Proctor admitted on the stand in front of a federal grand jury that he minimized his relationship with the Albert family. And if that doesn't just shock your socks off, I don't know. I mean, I shouldn't say shock, because we all kind of knew that was happening, but the pushback from that about, because Proctor's not the only one minimizing it. Everybody who's, already made up their mind on guilt is also minimizing it, saying that, we're all just blowing it out of proportion, that, making a mountain out of a molehill and stuff like that. And so it's kind of vindicating to hear that Proctor, in front of a federal grand jury, being questioned, admitted that he minimized his relationship with that family. That's huge. The other huge thing for me on this, I think, is the federal investigator from the feds. This is the feds. This is not the Commonwealth. This is not the defense. This is federal investigators did a reconstruction and said his injuries and the car damage do not line up. Those injuries would not have come from that car the way it is, and that car the way it is would not have come from hitting John O'Keefe. And that's huge. And that's not, you know, defense trying to spin things. That is federal, totally separate from defense, totally separate from Commonwealth, completely independent of everybody involved. Feds did that and said that math ain't mathin'. And it's the things that some of us have been saying all along, and we're called conspiracy theorists, and we're called, you know, we're called all kinds of things, let's be honest. But I have never once pretended to know exactly what happened, but I know that what they're saying happened doesn't make sense to me. And I know that their behavior during all of this, the Commonwealth, the police, and all that, I know that that is way out of line. I will never pretend to know exactly what happened that night. I know that there are very specific theories from the defense and from other people, and that's fine. I don't pretend to know either way, but what I do know is that there are so many issues in this investigation. There are so many issues with the Commonwealth and their behavior. There are so many issues with the DA and that ridiculous video that they were talking about. I played that, if you'll remember, I played that after one of the hearings, and we watched it and we went through it. And I had Bob from Defense Stars on here, and because he hadn't seen it, and we went through here, and I kept talking about how inappropriate it was, how it was just crazy to me that a DA would put something like that out. Like telling, you know, the whole population she's guilty, and, you know, all of the witnesses that we have are credible and they're not credible. And that the whole thing was just mind-blowing to me. And so they're bringing that up now, saying, yeah, it is mind-blowing. Like, that's totally out of line for what a district attorney's office should be doing. And it's like all of the things. It's a lot. I think that, and I've said this from the beginning, at a bare minimum, there is more reasonable doubt that you could not, there's no possible way to convict. There is no possible way to convict. None. If there was ever a case that had reasonable doubt, this is it. The beeping is on the feed. It's crazy. It's funny too, because he brings up the text between Turtle Boy and Karen, and he's like, see, they were texting. They have a relationship. But then when it's like the text between Proctor and the Alberts, it's like, oh, text don't matter. Kind of funny. Yes, there's a beeping sound coming from the feed. Y'all are not all losing your mind at the same time. Are we getting a decision today? I seriously doubt it. She will more than likely say that she's going to give a decision in writing. And I know there's some other motions that their defense is going to file by the end of the day. So
All right, you had a question, Mr. Jackson?
I did, Your Honor, just about the logistics of the trial, meaning days in trial, half days, 5 days a week, 4 days a week. I wanted to get some sort of sense so we can begin planning.
Okay, so we're going to go full days, Monday, Wednesday, Friday, half days, Tuesday, Thursday.
Are the half days afternoon or half days morning?
Mornings.
Okay.
Okay, anything else right now?
Can I have one moment?
That part stands out to me too. I mean, if it.
No, Your Honor, thank you.
All right, anything from the Commonwealth?
No, Your Honor.
Mr. McDermott?
Judge, I just wanted to put on the record that I think I provided to everyone copies of that letter from Google. I just wanted to make sure, just put that on the record that I gave you copies of that. Thank you.
We received copies.
Great.
All right, great. All right, thank you very much.
Thank you, Your Honor. Thank you.
Honestly, I don't know. She is not in custody. She is out on bond. You know what though? We kind of said beforehand that what was our poll, like 75%, I think is what it ended at. 75% said she ain't gonna rule in favor of the defense on any of these. But this is on the record now.
Yes.
So for appellate issues, you know.
Thank you very much. I really appreciate it. Great. Thank you.
So here, could you read this? In theory, I need to make copies of this for at least 2 people.
So.
Yeah.
Good work, Tim. You get a shout out there. Everybody still knows it.
Yeah, he said he saw a Ford Edge. But that killed me. Good Lord. Oh, my earballs. That killed my ears. All right, let me see if I can find if they do a any statements or anything outside. Let's see here. Oops. Filters, live. I don't see them out there doing one as of now. We'll see. If I see them come up, because sometimes they'll make statements to the news, so we'll watch. So, let me give you Lucy too. So, this one is, so this is a lot of, this is a lot of mess. The biggest things, I think, the takeaways from this are, like I said, the information about Proctor minimizing his relationship, like actually admitting that to a federal grand jury is wild. Okay, so let's start from the beginning. The first thing about Chris Albert and Michael Lank getting in the bar fight years ago, and then Lank, this is something that I had talked about on one of the lives I think that we did, the relationship between Lank too, because Lank was, his name is all over the reports too. He was one of the ones who who showed up. He and Chris Albert are friends. Obviously, Chris Albert is the brother of the homeowner where John's body was found. Chris Albert and his wife, Julie, who is the one who was texting, or the one who was going to, that they were texting about how she was going to watch Proctor's kids. Chris and Julie are married. They were there at Waterfall Bar with them that night. And it's Chris's brother, Brian, who was the homeowner where John O'Keefe's body was found. So Lank, one of the officers who gave statements and all of that, said that he was going to, during this bar fight or whatever, he was going to deputize himself, and he came to help Chris Albert. And then he said both of the two guys who he got in trouble for, or who got in trouble for that bar fight, were found not guilty. Lank was the first one, and I brought this up on the podcast. Lank was the first one to go meet with the Alberts, and I said in the podcast, he said after formal introductions, as in introducing to another person. There's no formal introductions when you already know them and have known them for years and years and years. That's no longer a formal introduction. That's not how formal introductions work. It's crazy. So that's not how that works. He also said that, and I brought this up on the podcast, that they got the phone numbers from them. They already had their phone numbers. They already had them. So, first person to go talk to them, to meet them, is automatically, very first thing in the police reports, misleading and misrepresenting the truth. And that's a huge red flag. And if that were the only red flag, then that would be one thing. But it's not the only red flag. It's just the beginning. It's like the first red flag in a whole red flag circus. It's crazy. So he said, he brought up Lank. That was one of the things, one of the examples he gave. And he said, that because that was the first person that Albert's talked to, Brian Albert, he's the homeowner. He was waiting on, a friendly, I think is the way he worded it, to come talk to them. And, that's what he got in Lank. And he said that even the grand jury was shocked by that. Then the thing about Proctor, that was his next one. Proctor withheld from the grand jury that there were conflicts of interest. Lank even obviously knew about this conflict. So, he calls in Massachusetts State Police, and they send Proctor. But the whole reason for avoiding, the police that were there is because of Kevin Albert, another one of them. So in order to avoid that conflict of interest, you call Massachusetts State Police and send another conflict of interest? That doesn't make sense. Oh, I'm sure she is. Look, she's got me blocked. She is the only person that I've ever cussed out on the internet. And I'll just leave it at that. So the huge things with the conflict of interest, the Fed's information shows that, what do you say, 10 days before John's death, Proctor was in text talking about Julie Albert babysitting their toddler child. Now, to have a kind of relationship with somebody who you trust enough with a toddler is huge. That's huge. If you are close enough with that family to trust them with your toddler child, or any age child, let's be honest, any age child, then you are too close to be the lead investigator on this case, period. There shouldn't be any argument here. There shouldn't be, I mean, I don't, it blows my mind that people defend this. And the people who defend this are not defending this because they believe it. They're defending this because they want Karen Read to be found guilty, because they, want to minimize all of these things because it goes with their narrative, because they hate Turtle Boy, because, the hate on both sides is so insane and just vicious that they would rather ignore the things that should be red flags for everybody in order to keep with that narrative. That's how it feels, and it blows my mind. This should be one of those, if you put aside everything else that you know about this case, if you hear that there's just a random case, you've never heard about anything, you don't know anything about anything, you hear that there's a random case where the lead investigator has personal relationships with the family where a dead body of a police officer was found, how can you say that that's not a big deal? And if you can say that that's not a big deal, then I feel like your judgment is not coming from logic, reason, or justice. It's coming from personal feelings about this case or the people who are involved in it or the people who report on it. Because there's not a way for me to understand saying that that's okay. The only thing that all of us should want is truth and justice. That's it. That's all any of us should want. Now, yeah, everybody might have different ideas of what that is, but that's all any of us should want. And if you cherry pick parts that work for your theory and not disregard, things that go against it, that's not justice. That's not justice. 3 days after John's death, Proctor and his sister are texting, and she just saw Julie Albert, and Julie said, when this is over, she wants to give you a big thank you gift. What? She wants to give you a big thank you gift when this is over. That, again, put this separate from anything else that you think or feel or know about this case, and put that, just that little piece of information on a whole separate case. How is that okay? How is that not a red flag? How does that not scare people? After this is all over, I want to get you a gift. You are the lead investigator on a body that was found in my family's yard. Let me get you a gift. Do you not see how that's not okay? Then, of course, the federal grand jury, Proctor testified when he was given examples of his ties to the Alberts, and he's being questioned on them, that he does socialize with them, and he does go out drinking with them, or whatever he said. He does do all of, these things with them. He has a relationship with them. And he told, Buchnick, or whatever, I can't say his name, told him, who's also working on this case, told him before they interviewed Chris Albert. So this is not something that was like, that nobody knew. They knew that he had a personal relationship with them. He admitted it to a federal grand jury during questioning. He admitted it. I mean, he's caught in the lies on the stand at the federal grand jury. People are asking about, or they're not people, they're questioning him, asking about, the Alberts, and asked, were you minimizing your relationship to them? And he said yes. He said yes. It blows my mind. The how long to die in the search, or how long to die in the cold search at 227, it seems to still be something that people are apparently still arguing over. Some people believe whatever side goes toward their theory. I personally feel like I went into this, like I said, wanting truth. I'm not looking for, to cherry pick things that go for what I am. I'm not looking to find who's guilty. I'm not trying to, say the Alberts did this, or say this is what happened. That's not what I'm doing. What I'm doing is looking at the evidence as it relates to Karen. And because of that, I don't have the need to pick information that makes someone else look guilty. So, having said that, I don't need to choose which side I believe on the 2:27 a.m. search, because I'm not trying to make the McCabe's or the Alberts guilty. But I do believe that it was at 2:27 a.m. And the reason for that is because while making the podcast, I talked to, I have his whole huge, explanation as to how, on the iPhone exactly how it was, and that there's no question about it. And when defense even got back up, they said, they're telling you that it happened at, after 6 a.m, but what Lally's not telling you is that they also said it happened at 2:27 a.m. So Jen McCabe's statement was that she looked it up at, after 6 a.m. after they had found him because Karen told her to. Now, do we know if Karen told her to? No. We don't know. We only know what's in the statements, and those statements and interviews were not recorded. And, when defense asked for notes that were taken during them, there were no notes. So, so we just have to rely on what they've given us. And we don't know if all of the statements that change so often are changed because of the witnesses changing their statements, or because the police are changing their statements or getting it wrong or whatever. We don't know. So all we know is that it's not consistent. And that's that 227 search. And now that I'm done with treatment, I plan on trying to finish the podcast episodes. Now that I'll have hopefully a little bit more energy, a little bit more time. But I have this whole thing from, a phone dude who I found to specifically, I was like, explain this to me like I'm 5 years old. And so I have the whole thing, and I'm like, okay, makes sense. 227. So Lally, again, minimizes the whole thing with Lank and says, it's from 20 years ago and doesn't involve anybody at the house. Okay, it involves somebody that was with them that night and was this is their family. This is a very close family. They were all there together that night. And he says that that Chris wasn't at the house, but we know that they were all together that night, and it's his brother. That they're, all really close. He said that nobody in the neighborhood came out. Okay, but we've seen the pictures, right? I've seen the picture. I've showed you all the pictures on my lives and stuff. Those houses are not this is not a neighborhood where the houses are very close together. A lot of them are, kind of, it's like nice size yards and stuff, The house next to them has, there's some trees and stuff that kind of are right there by where it went. But so it's not one of those things where you would expect everybody out there watching everything that's going on. But the thing about that is how nobody in the neighborhood came out. Not everybody had a dead body on their yard. Not everybody had a dead body on their yard. So what does it matter if nobody else came out? They had a dead body on their yard. Supposedly, another cop, a friend, and they didn't come out. It doesn't matter if the neighbors didn't. Maybe the neighbors were out there peeking like this. The neighbors didn't have a dead body in their yard. They did. I don't know. I feel like sometimes it's just my mind is just blown sometimes by the things that people excuse and say aren't a big deal, and it feels like it's done because they want so badly for her to just be guilty. There's a whole huge group out there that doesn't give presumption of innocence. And I get that with some cases, like the one that we're watching this afternoon. I get that, presumption of innocence for David Murdaugh is gone. There's we heard from the lady yesterday. He shot her in the face. She lived to tell about it. He was sitting there in the driveway with the gun when police got there. Presumption of innocence for him is gone, even though the trial's not over. We already know what happened. He even called 911 himself and said, I just shot 2 people. I had to get rid of the devil. So in cases like that, okay, presumption of innocence is gone. Evidence is already overwhelming. There's not a question. But when it's something like this, where there's so much reasonable doubt, how do you I don't get it. And maybe I'm not meant to get it because it's just not how my brain works. But I'm glad they brought up the video about Morrissey. That was actually kind of funny. Him saying that there was a law teacher who used that in his class as, an example of what not to do. That's actually kind of funny. And I think it was good the way he explained, like the DA has so much power when it comes to when it comes to everything. Like they have so much power over people's lives, and the way that he is treating this, defendant who is supposed to have the presumption of innocence is it's wild to me. It really is. And he said, he called it, he said, Marcy is not doing this to get justice. He's doing this to win. And that's exactly how it feels. And he gave the okay. Did I hear him right? He said that Marcy gave the okay for Higgins and Albert to destroy their phones. Did I hear that right? He said that was in the Fed stuff. I have to go back and listen to that. I was like, wait a minute. That can't be right. Higgins and Albert. So witnesses who were there, I have to go back and listen to that. So I don't know. Let's do a poll. Do you think the DA's office should be disqualified? Yes or no? Crazy. Okay, so we also hear logistics of the trial. So they're going to do full days on Monday, Wednesday, and Friday, and half days in the mornings on Tuesdays and Thursdays. I mean, this is going to be a big one. And I'm running out of time now that everything's done. I need to get my next couple podcast episodes out before the trial starts. The federal, and tell me in chat, what do you think are the biggest takeaways from this? I think for me, the two are the Proctor admitting that he minimized the relationships, and the federal investigator, completely independent of both sides, the feds said that the injuries and the car damage do not add up. That alone is reasonable doubt. That alone is reasonable doubt. Netflix had a documentary called Trial 4 that had to do with Boston's shady PD and DA work. Yes, that's actually a great documentary. And the attorney that was in there that fought for the appeal, she's a bulldog, and she's smart and talented. She was actually the attorney for the paint-dry trial, fresh paint trial. The car info is it for me. The car thing is so huge. That's so huge. The Fed's expert just said he wasn't hit by a car and her car didn't hit him. What they said is that the damage that was done to the car does not match, would not have been done by hitting John O'Keefe. And they said the injuries that John O'Keefe had would not have come from being hit by that car. That the damage to John and the damage to the car do not line up. That, in and of itself, is reasonable doubt. Feds, independent investigators. We all know how trials work. You can get an expert to say, not get them to say, let me rephrase, because I don't want to make it sound like everybody's dirty. You can find investigators, if you look hard enough, that will corroborate your theory. It always happens, every trial. And then each of the experts will testify, and the jury has to decide based on that testimony who they put more weight into. So if you hear both experts telling you, based on my expert opinion, this is what I think happened, and you can hear the other one saying, based on my expert opinion, I disagree, I think this is what happened. You can listen to both, and the jury listens to both, and whichever one they think makes the most sense is the one that they will generally put more weight into. So that's not the case here. This is separate. These are separate investigations. And he said there was multiple that are federal. This is not finding somebody to say what you want. This is federal investigation. Federal independent investigators. Multiple said, nope, that ain't how that happened. Oh, yeah, How to Fix a Drug Scandal. That was also Massachusetts. Oh, and there's a new one on HBO about that older case in Boston where, I can't remember the name, the guy calls the police and he's in a parking lot and he says that his pregnant wife was just shot and that it was a black guy that did it, and he had on... he kind of described like an Adidas type outfit. I think he said it had like the stripes on the side or something like that. And at the time that was like the style. That's what everybody was wearing. So it was just a very generic. So that, I won't spoil it on what happens. But anyway, I can't remember what it's called, but that one's on HBO. That one's really good too. And that one kind of goes over some of the Boston corruption also. This is like a long... Jon Stewart, yep. Charles Stewart, Jon Stewart, whatever it is. That one was really good. Yeah. Charles Stewart, okay. Y'all know my mind, I can't remember everything, all the names. But that one's really good too. So this was wild. This was wild. We have, yes, trial 4 is Sean Ellis. That one was really good. Okay, I'm going to end our poll. 94%. Let's see if that's what it says. 94% say the DA's office should be disqualified. I agree. If you are new to the case or don't know that much about it, I have the podcast is on Apple Podcasts. It's on Spotify. It's on everything. It's also on YouTube. But I have the podcast that goes over everything. I had to put it on hold. I think my last one that I did was like end of October, like right before I started kind of getting sick and tired all the time. So I kind of put it on hold while I was going through treatments and stuff, and now I'm done. So I have to try to get back on it. But I have that if you are interested in hearing some of the information. It kind of goes over like the details of everything. Everything comes from court documents, and it's very fact-based, but also I talk about the theories. So I don't present the theories as, you know, this is what happened, but I talk about the theories like from the defense and the theories from the Commonwealth about what happened and all of that. So, but it's my labor of love. So check that out if you want to get more information about it. All right, we have about an hour, I think. Let's see. I'm going to set us up to let me do this. I'm going to make it to where it portals everybody over to the next stream. So here's the thing for the next stream. The plan is we can watch the, let me save. There we go. We can watch the openings that they finally posted from our trial yesterday. And we can kind of speed trial through the others. Now, I'm going to change the time on it because I didn't know how long this was going to take. I didn't realize she was going to give them 10 minutes when she had originally said this could be all day. So what do I know? But I'm going to change the time on it because I had it set for, I think 12 my time. Is that what I had it set for? Yeah, I had it set for 12. So let's do 11 my time. That gives me an hour. That way I can take Lucy Girl out and get some stuff ready. And we'll speed trial through it. Also, thank you, Vicky Joe. Thank you. She heard me say that. I know, I'm going to take you out, baby. Also, the Scott Peterson hearing starts at the same time we're coming back. He's appearing from Zoom, but I believe they're going to have cameras in there. So it's not supposed to take long, but I'd like to watch that. That's so huge. Like I said, I named my kid after that baby, after Connor. So, so if it is shown, I would like to watch that before we get started. And then we can do our opening statements that we missed yesterday and then speed trial through the rest of the day. Sound good? Sound like a plan? The tail's already wagging. I know, she heard me talking about it and now she's like, what? We get to go out? We get to go out? All right, y'all, I appreciate it. Thank you so much for hanging out with me. Thank you for watching with me. If you have not seen it yet, check out the podcast, or heard it, I should say, yet. Check out the podcast. It is something I am very proud of. All right, I will see y'all in 1 hour, jurors. You're dismissed. Report back in 1 hour. It's going to portal you over there, so go ahead and hit notify me while you're there, and hit like while you're there. Go ahead and get that out of the way too. And I'll see y'all in 1 hour. Bye.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel. And
Good morning.
Goodbye, good people. Now, how the heck do I get out of here?